Good day, everyone, and welcome to the second semester. So, for now, this is a continuation of your RFBT, right? So, Law 201 basically tackles about obligations and contracts, and and law 202 basically covers about partnership, corporation, and cooperatives. So law 202 is on business laws and regulations under your RFBT board subject. So let's start with Chapter 1 talks about partnership. Partnership is under the new civil code from Articles 1767 to Article 1867. So 1767 tells us that by contract of partnership, two or more persons bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. So, by first paragraph, we could readily see that a partnership exists when two or more persons um, place their money, property, industry, pwede ding effects, labor, and skill to a lawful business with the understanding that there will be proportionate sharing of profits and losses among them. And paragraph 2 tells us that two or more persons may also form a partnership for the exercise of profession. What is then a profession? Well, basically, ang profession po ay yun po yung tinatawag nating mga calling. Those individuals, those persons who have learned art or experts or education, they have academic learning na required, they render public service or engage in that calling. Basically, it's still a means of livelihood. So, paragraph 2 contemplates about a form of general partnership. A form of partnership. We call this one as a general professional partnership, or a partnership for the exercise of profession. Strictly speaking, the practice of a profession is not a business enterprise for profit. However, our law allows that joint pursuit by two or more persons as partners, it could be under Article 1783, still of the new Civil Code. The law does not allow individuals to practice a profession as a corporate entity. Why is that? Because personal qualifications such as age, good moral character, college degree, cannot be possessed by a corporation. So you know for that. What are then the characteristics of a partnership? Partnerships is a form through a voluntary agreement. It is an association for profit. There is a mutual contribution to a common fund. There is a lawful purpose or object. The mutual agency of partners. The articles of partnership must not be kept in secret. This is very important because it is a requirement under the law, or else it would not have its juridical personality. And then we have the separate juridical personality. We will take this up, although we have taken this up in your other subjects, yung separate juridical personality na kung saan yung business daw is like a human being and should not be treated the same as to its owners. Now let's go for the characteristic elements of a partnership. So basically, a contract of partnership is consensual, bilateral, preparatory, nominate, onerous, commutative, and principal. Contract of partnership, in essence, it's actually a contract of agency. Why is it consensual? Because it is perfected by mere consent. Why is it bilateral? Because it is entered into by two or more persons, and the rights and obligations arising therefrom are reciprocal. So take note of that. Why is it preparatory? Because it is being entered into as a means to an end. What is the end? Well, to engage in business for the realization of profits, and with the end view, of course, of dividing that among themselves. It is nominate. Why? Because it has a special name. We call that one a contract of partnership. It is onerous. Why? Because contributions in the form of money, property, or industry must be made. This is very important. It is commutative. Why? Because such undertaking of each of the partner is considered as equivalent of that of the others. There is a community of interest. There is a contribution of funds. And each of the partner could expect a return or profit sharing. So that is why it is commutative. It is principal. A contract of partnership is principal. Why? Because the existence or validity does not depend on some other contract. So, for this one in your obligations and contract. What are then the elements of a partnership? It is important that there must be a valid contract. So as if hope you could still recall that since partnership is essentially contractual, all the requisites of a valid contract must be present. Well, under the law, natatandaan nyo ba yung atin pong COC, right? So, consent and the capacity of the contracting parties. There must be the object, which is the subject matter of the contract, and then there should be the cause. Next, there must be a contribution in money, property, or industry to a common fund. When we say money, it is under our laws, it should be the legal tender or currency. Ano yung medium of exchange is authorized or being adopted by a government through the Bangko Sentral ng Pilipinas. So, accounts receivable, hindi po pwede. Property, so anything, right? Which you have the right to possess, you have the right to use, you have the right to enjoy, yun yung iyong property. So it could be contributed. What are those? It could be real, it could be personal, tangible, intangible. So, my question now is, do credits such as promissory note or other evidence of liabilities or obligations could be contributed? And what would be the classification? Is it money, property, or industry? So, siya po ay property po pwede yun. And then industry. You know what is an industry, right? So, your expertise, your intellectual prowess, your efforts, manual efforts, your labor could be contributed to the partnership. Next thing, another important element is that it should be organized for gain or profit. So essentially, it should be the very intention of the existence of a partnership. So to obtain pecuniary profit or gain directly as a result of your undertaking, diba? So this is what distinguished from any other voluntary na associations such as yung mga religious associations. Kapag po nagkakaroon na ng division of profits and losses, well, there would be, if it is already organized for gain or for profit, well, we should think twice. It could not be a religious or a social organization. It could be characterized as a for partnership which is being organized for profit. Ano? So even if the business would be unprofitable, as long as that the very goal of that is to obtain profit, we could still say that it is a partnership. So, take note as well, hindi naman din ang realization lang ng profit ang exclusive aim ng partnership. It is also sufficient na yung principal purpose, even if there are incidental, yung mga moral, social, or spiritual ends, po pwede yung isama. Pero pag nagkakaroon na nga ng sharing of profits in certain proportions, then there could be a partnership na na-form. Another is that it must be exercised for a lawful purpose and established for the community of interest. So, first one, we have it should be for a lawful purpose. So, there should be the legality of the object or pursuit. So once it is contrary to law, to morals, to good customs, public order, or public policy, as what we've known in our previous law subjects, then it could not be it should be the contract should be considered void from the beginning. There could be no partnership, diba? Because void contract is without force and effect from the very beginning. And take note as well under this element is that there are certain businesses that the law does not allow to be formed or to be engaged by a partnership. What are those? Well, basically, under the General Banking Act, banks are not allowed to be engaged into by partnership, only a corporation, a stock corporation. So those are the very important elements. Take note of that for the important elements of a partnership. Next thing, we'll be discussing about the principle of Delectus personae. Ano ba yung principle ng Delectus personae? So basically, tatandaan natin na yung daw, ang partnership relation ay based on trust. At may kinalaman po itong sinasabi nating doctrine ng Delectus personae or yung right to choose with whom a person wishes to associate itself. Ito yung very foundation po ng partnership. So, dito, very important among the partners kasi po, meron po mutual agency na nag-a-arise. And, well, although they don't have the right to dissolve the partnership, they have the power, if justified, for the dissolution of the partnership, of course. So, the rule is that when personal relations are important, a person could not be compelled to associate with any other person because of this principle. So, one has the right to select the person or persons na po pwede pong magpo-form or who could become part of the partnership. Yun yung sinasabi nating principle ng Delectus personae or the idea that a partnership is based on trust or fiduciary na relation. Let's now go for Article 1768. Ano ba ang what is being said by Article 1768? 1768 tells us that the partnership has a juridical personality separate and distinct from that of each of the partners in case of, where is that? In case of failure to comply with the requirements of Article 1772, first paragraph. Before we will tackle of 1772, let's talk about what is a partnership being a juridical person. So we have learned in our previous law subject that to be considered as a juridical person, and as what we learned before, a partnership must fulfill nga yung mga essential requisites. Yun po yung ating mga essential elements, that there should be two or more persons that contribute money or property in a valid contract with the intention of dividing the profits among themselves. Well, so and so. So, it may be constituted ang contract ng partnership in any form. Kasi nga, consensual nga siya, di ba? However, there are certain instances na ang public instrument ay necessary. So, especially if there would be an immovable property or real rights which are being contributed to the partnership. So, that implies that since a contract of partnership is consensual, an oral contract of partnership is as good as the written one. So, express or implied po pwede. Kapag naman there's no immovable property or real rights which are involved, well, what matters is that the parties have complied with the requisites before as what I have mentioned. So, kapag sinasabi nga natin may juridical person ang partnership, then, like a corporation, it could be sued 'Di ba? Para siyang human being. As an independent juridical person, a partnership may enter into contract, can acquire and possess property of all kinds in its name, as well as incur obligations, bring civil actions or criminal actions. So, pwede ding i-declare ang partnership na insolvent kahit po si partners ay hindi naman. And then, ano pa ba? It is sufficient that service of summons be served on any partner. Well, basically, these arise on the idea that there is mutual agency in the partnership. Each of a partner is an agent of the partnership. So, partners, when we say there, it is a juridical person, it cannot be held liable for the obligations of the partnership unless it is shown that the legal fiction of a different juridical personality is being used for fraudulent or unfair or illegal purpose. So it means to say that in the contract of partnership, kapag sinasabi natin siya ay juridical person, kung si A and B forms A and B partnership, basically there are three persons in that scenario, right? So person A, person B, and the AB partnership. So yun po yun yun po yung ating idea. Yun po yung ating ideya kapag sinasabi po nating merong juridical personality ang isang partner. However, let's resume. Under 1768 nga, may sinasabi siya na ang juridical personality nga ng partnership, the partnership has a juridical personality separate and distinct from that of of each of the partners. So the partners therefore cannot be held liable, etc., etc. So it means to say then as well that the partnership, not its officers nor its agents, should be impleaded in any litigation involving the property registered in its name. What would be the effect if there would be failure to comply with the statutory requirements under Article 1772? Ano ba ang sinasabi ng 1772? According to 1772 kasi, every contract ng partnership na may capital na 3,000 pesos or more in money or property should appear in a public instrument. Tapos, dapat din siya recorded in the Securities and Exchange Commission. However, failure to comply with this requirement will not affect the liability of the partnership and the members thereof to third person. So it means to say that meron pa din siyang juridical personality in terms, even though non-compliance with the requirements of 1772. So, tama ba? So, yung ating pong reference with reference to the execution, bakit? What is the reason for this? Kasi the law, the Philippine law recognizes na most partnership naman ay created with very small capital and then they engage in small businesses. So, minsan, it would be impractical and inconvenient to require the parties to comply with the requirements under 1772. Paano naman under 1773? Ang sabi kasi ng 1773, dapat daw yung pag nagkakaroon ng dapat kapag nagkakaroon ng contribution in real property, regardless sa value, is contributed by any partners, yung failure to comply with such as yung contract ay dapat sa public instrument, na dapat may inventory of the property contributed, and then signed by the parties, and at the same time, attached to the public instrument. Importante yun. And what would be the effect if non-compliance with 1773? And then at the same time, 1775. Ang 1775, yun yung according to 1775, yung associations and societies whose articles are kept in secret among the members, and wherein any one of the members may contract in his own name with third person shall have no juridical personality and shall be governed by the provisions relating to co-ownership. So basically, ang 1773, kapag may immovable property, pag hindi po nagko-comply sa requirements, shall not acquire any juridical personality because the contract itself is void. The same thing in 1775, kapag po yung atin pong articles of associations and societies, if it's not divulged or disclosed, then hindi siya po nakaka-acquire ng juridical personality. And being mentioned as well, yung to organize a partnership is not an absolute right. It is subject to limitations. It is just but a privilege which may be enjoyed only under such terms, and the state may deem necessary to impose certain limitations and certain requirements. Yun yung pag-i-engage ng business ay hindi po siya absolute right. Hindi porket may puhunan ka ay po pwede kang magbukas na ng negosyo. Etong yung mga requirements ay siniset nga because it's just a privilege. Let's now go for 1769. What does 1769? But before that, maybe I have mentioned a while ago, or if I'm not, basically the very tests before go for 1769. Sa 1767 pa lang, malalaman na natin yung very tests para ma-determine natin kung ang isang scenario or isang setup ng individuals ay yun ba ay partnership? Firstly you should determine whether there is agreement na magko-contribute ba ng money or property or industry to a common fund. Pag wala naman, then it's a different form. Ang second test naman, you should determine whether or not meron bang intention yung mga parties to divide the profits among themselves. Then, if those are present, then you could readily tell na meron pong na-form na partnership. Let's now go for 1769. Under 1769, in determining whether a partnership exists, these rules shall apply. So let's start with rule number 1, except as provided by Article 1825. Persons who are not partners as to each other are not partners as to third persons. It's like a tongue twister lang So what does it mean? Ang example nito, let's say for example, A and B are not partners naman. Hindi naman sila partners talaga as to each other. Of course, kapag may third person dyan, it follows na sa mata ng third person, they are also not partners. Ang exception lang yan kapag alinman kay A or kay B, alinman with A and B, they misrepresent themselves to a third person and would tell the third person na they are a partner. So, kung si A man yung nag-misrepresent himself as a partner and then B has consented to that, tapos wala siyang pag-o-object in front of a third person, there they would be considered as partners by operation of law. Ang tawag natin doon ay yung partnership by estoppel. Yun yung concept natin ng partnership by estoppel. Partnership by estoppel yung where a partnership not duly organized has been recognized as such in its dealings with certain persons, it should be considered as partnership by estoppel. And then the persons dealing with it are stopped from denying its partnership existence. Yun yung ibig sabihin. So, hindi ka na pwedeng mag-deny na walang nag-exist na partnership kapag naman nagre-represent ka sa public na you are partners. And non-denial or the consent of the other person, it's like the consent o walang objection, well, it needs to say na siya ay pumapayag na nagkakaroon sila ng voluntary agreement to become partners. Rule number 2. In determining whether a partnership exists, let's have number 2. Under number 2, where is that? This is quite long than I expected. I was thinking this is just very short. Number 2, co-ownership or co-possession does not itself establish a partnership, whether such co-ownership or co-possessors do not share any profits made by the use of such property. Kailan ba nangyayari ang co-ownership or co-possession? Let's say for example, yung limang magkakapatid, namatay yung kanilang magulang, tapos naiiwan ang kanilang magulang ng isang ng pagpapalagay natin 5 ektaryang lupa. Kaso nga lang, hindi pa sila nagkakaroon ng manahan. Tapos may nakatayo doong building, hindi pa nila hinahati-hati. Ngayon, ang tawag doon sa relationship na yon ay co-ownership or co-possession. So, what's the difference now between a partnership and a co-ownership? Sa partnership, basically, it is being created by contract, whereas in a co-ownership, it is created by contract and law. So it could be that the parties would agree that they would be co-owners on that property that they have inherited from their parents, diba? Or by law, if there would be an agreement, automatic, since they are the property is not yet divided, then they would be considered as part owner of the property. When it comes to juridical personality, does a co-partnership has a juridical personality that it could be sued or it could acquire properties in its own name? Well, basically, no juridical personality ang co-ownership. So, for partnership, we know the purpose is for profit. Whereas in a co-ownership, the purpose is just the common enjoyment of the thing or right. It's not necessarily for profit. What if naman yung, as what I've mentioned, if there would be a building and then that building ay pinapaupahan, tapos they own both the lot and the building, if there would be rentals and then they would divide the rentals of the property, would it be considered na ang partnership ay nag-i-exist? No, still there is no partnership in that. So how should be the division of profits when it comes to partnership or and co-ownership? Well, in a partnership, as we know, it could be stipulated, it could be agreed upon, right? However, in a co-ownership, it depends upon on the proportionate na sharing on the proportionate sharing of the property. It is very important to know. In a stipulation that there would be no proportionate sharing, it would be void. Important yun. So, kung under the law kasi, kapag po ay wala pong agreement sa kung paano po hahatiin, there is a legal way of dividing the profits among the heirs of the deceased person. So how would you dissolve a partnership and how would you dissolve a co-ownership? So basically, to end a partnership, it's through a death or incapacity of a partner that would justify the dissolution of the partnership. Whereas in a dissolution of a co-ownership, it is not dissolved by a death or incapacity of the co-owner. Basically, yung co-owner, kapag siya ay may anak, mapapasa lang yung representation o yung kanyang rights over the co-owned property to his or her children. So, when it comes to form, does partnership or co-ownership differs as to their form? As we know, since a partnership contract is consensual, it may appear in any form. However, kapag nga under 1773, if there would be a requirement, especially when real property is being contributed, it should be in public instrument and registration with the Securities and Exchange Commission and signed by the parties and must be appearing in the inventory, yung kino-contribute na ng mga owners. So no, for co-ownership, there's no public instrument needed even if the real property is the object of a partnership. Hindi nila kailangan, basta co-owners yung mga iyan. Pag magkakapatid kayo, automatic heirs kayo at pwede na kayo magkasundo sa hati-hatian kahit walang, kahit yan ay real property pa. So, that is the second rule under determination if the partnership exists in certain situations. And now let's go for the fourth rule, in the third rule rather, in determining whether a partnership exists. The third one says that the sharing of gross returns does not itself establish a partnership, whether or not the persons sharing them have joint or common right or interest in any property from which returns are derived. So, ibig sabihin na to, pwedeng i-dispute, hindi ibig sabihin na na-establish ang partnership kapag merong sharing ng profits by two or more persons. Pero ha, if what is being shared by two or more persons ay yung profit, um, well, and then there is the contribution, by the parties, it could be observed and it could be said na meron pong nagaganap na meron pong nagaganap na partnership. So it should be and it still be disputed. It should be understood na talagang gusto nilang mag-establish ng partnership. Importante sa partnership na may contract, whether it's verbal or expressed na contract. Rule number 4 in determining whether there is a partnership. So, the receipt by a person of a share of the profits of a business is a prima facie evidence that he is a partner in the business, but no such inference shall be drawn if such profits is received in payment of. So, it's very understandable, right? So, kapag daw nakakatanggap ka ng sharing, profit sharing, yun ay automatic on its face indication or evidence na partner ka sa business. Pero hindi dapat nating i-draw out na yun talaga yun kapag naman yung payment ay talagang pambayad naman sa utang, 'di ba? Payment of death by installment, o wages, very understandable. Annuity to a widow or representative, o parang buwan ng pensyon, as interest of a loan. So, yun yung mga malinaw po. Through the amount of payment varies for profits of business. And though the amount of payment varies with the profits of the business, as the consideration for the sale of a goodwill of a business or other property by installments or otherwise. So, in general, to establish the existence of partnership, all of its essential features or characteristics must be shown as being present. So, in case of doubt, Article 1769 shall apply. So, this article seeks to exclude from the category of partnership certain features enumerated herein, which by themselves are not indicative of the existence of the partnership. So, you would only apply Article 769 if in doubt whether a partnership exists. So, ang first test natin, yung na-mention ko kanina, whether there is a contribution of profits, a contribution to a common fund, and then second is there is division of losses. If both are present, then it could be said there is a partnership. But if in doubt, apply Article 1769. Persons do not as partner to each other. Well, basically, this is still an explanation of 1769. So, here, the burden of proof of proving the existence of partnership rests on the party having the affirmative of that issue. The existence of partnership must be proved and will not be presumed, and then the law presumes that those acting as partners have entered into a contract of partnership Where the law presumes the existence of partnership, the burden of proof is on the party denying its existence. Take note ha, kapag daw ang batas ay nagpe-presume na nag-e-exist ang partnership, ang may burden of proof ay on the person na nagde-deny ng existence ng partnership. When a partnership is shown to exist, the presumption is that it continues and the burden of proof is on the person na asserting its termination. One who alleges partnership cannot prove it by merely evidence of an agreement using the term partner. Non-use of the term, however, is entitled to weight. The question of whether a partnership exists is not always dependent upon the personal arrangement or understanding of the parties. Parties intending to do a thing which in law constitutes a partnership are partners. So, ibig sabihin nito, yung legal intention, yun talaga yung pinaka-importante, is the crew of the partnership. So, the parties may call themselves partners, but their contract may be adjudged something different or quite different. So, conversely, parties may expressly state that theirs is not a partnership, yet the law determine otherwise on the basis of legal intent. However, the courts will be influenced to some extent by what the parties call their contract. So, meron din tayong mga tests or incidents of partnership. Yung sinasabi nating mga incidents, ito yung parang mga circumstansya, mga pagkakataon na makikita mo na talaga palang partnership ang kanilang ini-exercise.